Okay, this is the third segment of the online class. We left off last section with going through the 5 different jurisdictions of law, and now I'll be getting into talking about admiralty. Admiralty law and maritime admiralty, they're synonymous terms, and it deals with banking and merchant affairs. This is where you get the whole aspect of the law merchant coming onto the land. This is where it stems from. So, again, I'm reading from Chapter 7 of my Grand Jury Handbook. The courts of admiralty stem from matters on the sea regarding the administration of maritime law and banking and merchant affairs. A description of the creation of the jurisdiction known as admiralty from an elementary treatise on the common law by Henry T. Terry, 1906, page 112, with my notes. And again, this treatise can be found by going on to archive.org and searching for this particular treatise. You can find it for free. To begin, the Court of Admiralty is said to have been originally instated by King Edward III. Now notice that King Edward III had both maritime admiralty and equity established under his reign. So it's an interesting historical note. It was held before the Lord High Admiral of England, or a judge who was his deputy. There are really 2 separate courts included under the common name of the Court of Admiralty, the Instance Court and the Prize Court. The former is the ordinary court which administers the maritime law. The latter, the Prize Court, is a special tribunal only existing or at least only acting in time of war, whose function it is to adjudicate upon questions of prize. Now, a prize is when one ship takes over another ship out in the high seas. That is, of the lawfulness of capture made from the enemy and the disposition of the captured property. There were also vice admiralty courts in the colonies, and the vice admiralty courts were a real state of contention when it came to the colonists. They were not happy about the things that would go on in the vice admiralty courts, particularly dealing with all of the matters of American merchant vessels, being taken by pirates and English and just everybody. And of course the English would always go against the colonists, and that was a serious line of contention during the colonial years. So to continue my note, because the state of emergency has never been removed from the executive order of Lincoln, the courts you enter into, what you think are criminal matters, are actually prize courts under admiralty jurisdiction, and your body, the vessel, is being taken before these courts for condemnation and sale by land pirates who work for a corporation, or corp, or the cops, right? Those are the land pirates. So, as I said, they're running all of these jurisdictions concurrently. They're all running at the same time. And so you have to know that the different words mean different things. So the body under admiralty, it's still being a res, a thing, is from a standpoint that it's an abandoned vessel. So they're coming in and they're basically selling it. Okay, that's, again, the aspect of selling it for the bond. The bond aspect, as far as the maritime admiralty jurisdiction is concerned, it's called a bottomry bond, which is where you put a bond on the bottom of the ship to bond the ship in case the actual owner of the ship came forward and said, hey, that's my ship. So it's an aspect of ships adrift, if you will, right? Lost adrift in the Sea of Commerce. So to continue, the appeal from the Court of Admiralty, this goes back to the book now. The appeal from the Court of Admiralty was formally to the King in Chancery, the appeal being heard by a court of delegates commissioned by the King for that purpose. But by a statute of William IV, all appeals from the Admiralty and Vice Admiralty courts were to be taken to the King's Council, i.e. to the Privy Council. Note, an appeal is to appeal to the conscience of a man, not your peers. Also note that this appeal from the court ends up again in front of a black robe attorney, so this again is a continuation of the usurpation of power from the king and the people to the attorney. The Privy Council is also the ultimate court of appeal from the courts of the English colonies. This was also part of the problem. The powers of the Privy Council as a court are exercised by what is known as the Judicial Committee of the Council, comprised of lawyers appointed members of the Council for that purpose. Ladies and gentlemen of the jury, I rest my case. There you go. That's the whole deal. Composed of lawyers appointed members of the Council for that purpose. That's where Admiralty came from. Now, to give you a little bit more historical background regarding when Admiralty came into England at all. Yes, the Admiralty courts were established under William III's reign. However, that's not where the idea of the Admiralty law came from. Or sorry, did I say William? I meant Edward, sorry. Edward III. They came from what was called the Laws of Oleron. previous to that from Carthage, and previous to that from Phoenicia, Cana, the Canaanites. Okay, and the laws of Oleron were brought back by Eleanor. Eleanor was the mother of both King John and Lionheart. I believe it was during the First Crusade, but that might have been the Second Crusade. Don't hold me to that. And they brought the laws of Oleron back to England and thought, oh, this is a really great thing to do. We can make all this extra money in our courts by running this maritime admiralty law through our power. So that's kind of how it ended up lodging itself, if you will, in English jurisprudence. So to continue, though, let's get on to ecclesiastical. So without attempting to describe what this jurisdiction is, why it exists at all, or what it does, for in truth it escapes me, passage will simply be given again from Elementary Treatise on Common Law. Quote, before the Norman Conquest, that's William the Conqueror, 1066, there were no separate church courts. Take notice of that. The filthy serpent seed line of William the Conqueror coming over with Rome, power of Rome, bringing power of Rome into England, brought the power of the church courts, okay? The bishops sat on the popular courts and ecclesiastical causes were tried there. But William I forbade this, from which resulted the establishment of the ecclesiastical courts. The archdeacon's court is held in each archdeaconry before a judge appointed by the archdeacon and called his official. It is the lowest rank of all the ecclesiastical courts. The ecclesiastical courts were the ordinary courts for the probate of wills and the granting of administration on the estates of deceased persons. Notice that. Probate is ecclesiastical jurisdiction. They're running every single thing through probate. Why do these black robe fools sit up there? Why do they wear black? Because they're priests of El. El is in Saturn, which is another name for Saturn. El, God El. And El is the god of banking and lies. Surprise, surprise, right? The SS, the Nazis, they were one of the biggest and still strongest Saturnalian brotherhoods that exists on the planet as far as secret society is concerned. That's why you have a black robe priest of El sitting on the bench to run all this stuff through probate, because you're not coming forward and claiming your estate and getting it out of there. So this is where you have bishops interfering with the common law of rights of blood and kinship so that they control the distribution of wealth and land and title to who they see fit. Now back to the book. If the deceased left bona notabilia, that is, goods of value of 200 shillings or more, in two or more different dioceses, the probate belonged to the archbishop and was granted in his prerogative court. So now you've got bishops having their own prerogative. Great. Which was held before a judge appointed by him. So no. Now the bishops have been given the same kind of prerogative power that the king has. From the archbishop's courts, the appeal was originally to the pope, but after the Reformation, to the king as the head of the church. This is where you get into the whole back and forth with the Reformation and the Counter-Reformation of the people and Luther saying, to hell with the cult of Rome, to hell with the Pope, and where you get the Church of England being established. So I hope the reader can see where this is going from the start, giving power to the cult of Rome, which is something that Rome could never get over the people of the island by force, an aspect of learning about the Hadrian Wall. I won't get into that, but that's an interesting part of history as far as why Rome could never completely conquer the Isles. So this jurisdiction the king exercised by commissioners called the Court of Delegates, as in case of appeals from Admiralty, but it has now been transferred to the Privy Council. That's where you get the aspect of ecclesiastical law, and why it still matters today from the standpoint of probate. So again, all the power goes back to the attorney. It warrants mentioning that the history of England, to be raised by the attorney in all the aforementioned passions, is the same thing that we're facing in our American lands. What evil cannot be taken by force of arms, by miles, and in matters of months, they steal by deception of the attorney by inches over years and decades. It's the boiling the frog technique. Definition of canon, aspect of ecclesiastical law. Canon, ecclesiastical law, the word is taken from the Greek and signifies a rule or law. In ecclesiastical law, it is also used to designate an order of religious persons. Francis Duran says the reason why the ecclesiastics called the rules they established canons or rules and not laws was modesty. No, it's because they didn't have any power to actually decree law. They did not dare to call them laws lest they should seem to aggregate to themselves the authority of princes and magistrates, meaning they didn't have the power of the people, period. That's from Bouvier's Law Dictionary. So, it's not law. Just make a note of that. Now, let's go on to the last one, military. This again, same book. Military law is the law which governs the army and navy or the militia when in active service. It existed in a time of peace as well as war. It is mainly statutory. It must be distinguished from martial law, which later is indeed hardly to be called law at all. Martial law exists when, for military reasons, for instance, in case of the military occupation of an enemy's territory, the ordinary law is to a greater or less extent put into abeyance and the arbitrary authority of the military commander is substituted for it. Just to make a note here, it's important to understand that we've been under martial law since the Civil War. Executive Order 100, which is the Lieber Code, governs it until we the people come back over the top of them and say no to the rest of this idiocy. End the emergency, which has to be basically reestablished and reconfirmed by every president ever since then. Till that emergency ends and we get rid of this martial law stupidity, they're going to continue to place us into the aspect of military courts. So anyway, to continue, until we say no and say that there is no jurisdiction here and that, one, you're not an enemy combatant because you're one of the people. You are the Republic. All the power stems from you, and technically, under the Lieber Code, the army was put in place to protect the assets of the Republic. So technically, they still work for us. And I would rather just simply deal with things in courts of record and say, look, this is what we're doing, and basically you have to prove otherwise. In many countries, the government has power, even in time of peace, to suspend the ordinary law and proclaim martial law, or, as it is often called, a state of siege. Another interesting book you could read, Siege, but anyway, I digress. In the country at large, or in a particular places, putting them temporarily under military rule, when, in its opinion, special dangers threatening the state or the public safety, such as insurrection, require it. Well, you're seeing right now a idea of them trying to push an aspect of martial law, with this whole coronavirus thing, where you're saying shelter in place, blah, 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 this, that, next thing. They're trying to push this issue a bit. But as you can see, people around the nation are basically showing up at capitals with, hundreds or thousands of people, all armed, most of them, and saying, no, the hell with you. So, and it says, but this is not allowed in the United States or England. Well, someone should have told the author to get his history right, because it technically is what they're doing. Remember, this passes as a treaty on law, and not just the author's opinion. And notice it's the date of the treatise, 1906. So why then are we continuing to allow these unlawful courts to trespass upon extensive rights, right? So those are the 5 jurisdictions of law. Post an aspect of Ex parte Milligan from is unconstitutional to try civilians by military tribunals unless there is no civilian court available. So what do you have to do? You have to create your own court of record to make sure that the court is available. That's the point. Or else you're going to be de facto placed into being subject to military tribunals. So that's 5 jurisdictions of law from a standpoint of you're not subject to the aspect of statutes, acts, ordinances, or codes because of the reasons we just went through of understanding the 5 jurisdictions of law. So let's go down now to L. The presumption that you are bound to any unrevealed contracts, trusts, pledges, bonds, or oaths they hold over you as an infant. For no contract that you may ever have had with the corporate government can ever be valid because if you used Federal Reserve notes at the time for any, quote, contract license, it voids the contract for lack of consideration. See the Jerome Daly case, Federal Reserve notes, lack of consideration. So let's pull that up and we can take a look at the Jerome Daly case, which would be number 12. It's also called the Credit River decision because it was done in Credit River Township. And what it says, this was a case where shortly after Nixon dropped the gold or silver standard off the money, this man brought suit against the bank and said, look, I put up my house as collateral. What did the bank give me? Nothing. Because Federal Reserve notes have no lawful consideration. They're not backed by anything. So when you look at it, what they did, they put in an example. They literally put a dollar bill in as evidence. And the decision of the court was that this court determined that said notes on their face were contrary to Article 1, Section 10 of the Constitution of the United States. And also, based upon the evidence deduced at the hearing on December 7th, 1968, the notes were without any lawful consideration and were therefore void. And there you have it, right there. So, can you use a Federal Reserve note for a lawful contract? No, because it doesn't have any lawful consideration. That's the point. However, this court indicated that it would give the plaintiff, the bank, a full and complete hearing with reference to this issue, which the bank never took because, of course, they can't prove it. Okay. No hearing was requested, and this court was ordered to show cause before the district court as to why the appeal should not be allowed. Therefore, this court ordered a hearing before blah, blah, blah for the purposes of making and finding fact conclusion of law pursuant thereto. The above entitled action came before this court on January 1969, and First National Bank Montgomery made no appearance, although service of the motion was served. Defendant appeared on behalf of himself, and they waited for an hour, and then they filed the evidence offered in, and the conclusion was that because of the interlocking activities, transitions, and practices, the Federal Reserve banks and the national banks are, for all practical purposes in the law, one and the same bank. There's only one bank, people. They're all connected. As evidence in the book Federal Reserve System, its purpose and functions, which you can get from Board of Governors, and other evidence brought in, the Federal Reserve banks and national banks create money and credit upon their books and exercise the ultimate prerogative of expanding and reducing the supply of money or credit in the United States. They just create it upon their books. It's a bookkeeping entry. That's all it is. A little side note about bookkeeping entry. The first time bookkeeping entries were ever created or done in the way that they're now being done, they were done by the Venetian black nobility, so the Venetian bankers, right, who were appointed as the trustees under Unum Sanctum, which is the first testamentary trust of which the Pope decided to take the whole entire planet in trust. Ha ha ha, how fun, right? They were all followers of worship to Saturn, clearly. So yeah, and that's why the judge rules for the bank, the bench. Bench in Latin means bank. The creation of this money or credit constitutes a creation of fiat money upon the books of these banks. And it was found that no substantial fund of gold or silver is back of it, or any fund at all. Nothing. So this is a fairly long. It's 41 pages. I'm not going to go through the whole thing, but you just hit the. I'm hitting the high points here. But you can go through the rest of this, and you can see all of the rest of the evidence, the memorandum, so on and so forth, and everything else. It's a good case to throw in the face of any debt collector. Say, hey, are you going to disprove this? There's no consideration. I don't owe you anything. So that's Jerome Daly, so we'll set him aside. And now we'll go back to the outline and go down to the next one, which is M. So the next presumption is that your estate is considered abandoned, not claimed, and therefore requires administration. Okay, this is the aspect that no one comes back to claim little you at the foundling hospital after you've been abandoned for 7 years. So the word intestate, again, this is from Bouvier's, one who, having lawful power to make a will, has made none, or one which is defective in form. In that case, he is said to die intestate, and his estate descends to his heir at law. So when you're presumed dead after 7 years, did you write a will between the age of 1 and 7? Not usually. So this term comes from the Latin. Formerly was used in France indiscriminately. It was regarded as a crime on account of the omission of the deceased person to give something to the church, and was punished by privation of burial in consecrated ground. Ooh, oh no, I don't get buried in consecrated ground. Boo-hoo, right? So anyway. So just notice that once you do your status docs, your estate is no longer intestate, because they're all, like I said, they're all a continuation of your will. Okay, so that's intestate. So that's not having, from the standpoint that, excuse me, did somebody say something?
Yeah, I said something. I was going to ask you, what's your thoughts about actually opening a probate in order to file your will into the probate court in your county, in your home county?
Yeah, we'll get to that, because what we have to do is we have to eventually get to the point where we're opening a formal probate proceeding in a court of record to settle the entire gross estate, which is where you would place and file all of your status docs into to settle the entire gross estate. And that's the final point of all this, is to get that done. So that's intestate, so that your estate is considered abandoned. Let's move on to N. N is that anyone has come forward with a superior claim to your estate. So if no one has done so and you place first and highest claim on your estate, they must forever and let go and lose any claim over the same. That's exactly how we have it written in the KW. So a claim is a challenge of the ownership of a thing which a man has not in possession. and is wrongfully withheld by another.
Why do you have to have everything complete before you open that estate?
Because you don't have any standing. You don't have any standing to do anything in the estate until you've properly come forward and done proper standing on public record. That's the reason. As far as you open up a formal probate proceeding, yes, you have to ask for formal probate and then put it in basically as from a standpoint of the will formally put before the court to prove that you are who you say you are. It's the settlement of the estate. It's an ex parte hearing. So you have to bring a claim from the standpoint that a claim is a challenge to the ownership of a thing which a man has not in his possession and is wrongfully withheld by another. So what they're doing is they're wrongfully withholding your estate and the property thereof from you. So when you bring a claim, that's a proper challenge. That's what you're doing when you say, hey, look, I've claimed this. Now you do that through the status docs on the public record, and then you finish it by bringing it into a formal probate hearing. Once it's into the formal probate hearing, then now you say, okay, great. Who else is here? Are there any creditors, right? And this is the type of thing that happens in a same type of idea, the thing that happens at a bankruptcy hearing. So in a bankruptcy hearing, you start the proceedings, but you're the defendant. And in a bankruptcy hearing, you're basically saying, hey, I don't have the capacity or the knowledge or whatever, or I'm incompetent to handle my own affairs. The books have to be balanced. Well, in a formal probate hearing, when we're coming forward and claiming our estate as having proved life and that we're saying, look, this is mine, and we're making the claim to it, you're doing the same thing, except now you're the plaintiff. You're doing it in the proper capacity of the plaintiff, not as a defendant and saying, oh, all these creditors come and attack me. Nope. In formal probate, you're saying, I'm the sole lawful heir and executor, and this is mine. So you're making a proper claim. So to continue here, in Pennsylvania, the entry of the demand of a mechanic or material man for work done or material furnished in the erection of a building in those counties to which the lien was extended is called a claim. A continual claim is a claim made in a particular way to preserve the rights of a feofi. Now, this is an aspect of it being under feudalism. I just put the rest of these in here so you kind of know. A claim of connuisance is derived to be an intervention by a third person demanding jurisdiction of a cause against a plaintiff who has chosen to commence his action out of the claimant's court. So, what's your court? Your court of record. So, a claim of connuisance can also be brought from the standpoint that, hey, we're bringing everything into the formal probate. Everything else gets shoved into here, and you can do that from that standpoint. You can also do it from what's called a motion to consolidate, where you consolidate everything under your proper court of record. Claimant in the courts of admiralty is when the suit is in rem. That's, again, in rem is against a thing, a res. The cause is entitled to the name of the libel against the thing libeled. So when a person authorized and admitted to defend the libel, he is called the claimant. So that's just in courts of admiralty, though. So anyway, so that's what you're getting as far as having to put your proper claim down. So you do your proper claim in your status docs, and then you bring it to a court of record, or you just open up your court of record and say, hey, I'm claiming the estate. Who here has higher claim, or who here brings charge against this estate? And by what means do you do so? By what jurisdiction do you do so? Do I have a contract with you? Was there any lawful consideration exchanged in that contract? And if not, sorry, that contract's void. So let's continue on now to the next presumption, O, that you consent to any administration of your estate at all. So this next document, document 12, I'm not going to get into too much because it's fairly lengthy. What it is, however, is it's an email that I did a while ago to explain what happened to our estates. Now, much of this is going to be, it's very much a synopsis of everything that I've been talking about today. It talks about presumption of death, what the Roman scum has been doing for the aspect of right of use, gives you use usufructuary, citizen or people, which one are you? The aspect of that you don't want to be a citizen of the United States, you want to be one of the people. Nice little layout of interesting law and facts of that. It came from Bill Thornton, which is 1215.org. And the aspect of nationality and birth and collection, or collective nationalization. 8 U.S.C. 1401, this I will read. Nationals and citizens of the United States at birth. The following shall be nationals and citizens of the United States at birth. F. A person of unknown parentage found in the United States while under the age of 5 years, until shown prior to his age of attaining 21 years not to have been born in the United States. What is that they just did? That is a blatant presumption that they have right in U.S. code. Okay? It's a presumption that you have to rebut. Now, does that mean that after 21 you can't come back and do it? No, of course not. Of course you can still fix it. It just says that the presumption kicks in after 21. So that's where they're getting it from. So if people want to get on some bandwagon about being a national, great. They're still found to be a citizen of the United States at birth. So people that are harping about, oh, I'm a national, like what Anna Von idiot is telling people. No, doesn't help at all. Okay, you're still stuck under that. The aspects of the hospitals are foundling hospitals run by Knights Hospitallers. Pretty much covered that before, but there's a little bit more in there if you want. What is a person? This we covered before. And this little part of the DC code. This was one of the 1,564 codes that I found in the DC code when I pulled all of these that had the word estate in it. Okay. Appointment of guardians of the person by court, limitation number of wards. When an infant has neither a natural nor testamentary guardian, a guardian of the person may be appointed by the probate court in its own discretion or on the application of a next friend of the infant. The attorney must be acting as the next friend and putting it into the probate court. By the way, notice P and C, probate court, are capitalized. I'm looking, and I was still looking through the code to find it if there's a special meaning. But the probate court in DC will probably have to be a place where we do not bring the formal probate, but we'll have to notice them that a formal probate has been started in a court of record on the state side, which is a higher court than what theirs would be. Now, this is the other interesting part. Only trust companies may act as a guardian of the person for more than 5 infants at a time, unless the infants are members of one family. So what's that telling you? It's telling you the trust companies are the guardians. So the Depository Trust Company and Clearinghouse, DTCC, that's who's acting as the guardian. Q said that this all ends at number 55. That's what he's talking about. Okay? Or all of them, because I'm sure Q is more than one person. So I get in the Magna Carta, we covered that. Difference between executor and administrator, we covered that. And so this is administrator, Bouvier's covered that. So like I said, this is basically a synopsis of what I've been covering all day. But if you want to give a primer to someone as to everything of what's been going on, just give them this doc. Let them read all this. Let them go through everything, and then they'll get the point of it. Importance of being the heir, not the beneficiary. We covered that. Certificate of Act, covered that. The verbiage of the Certificate of is in the DC Code upon the persons whose life or prior state depends. And then I finished with the Mandel Edward House quote. And the Mandel Edward House quote, I did a whole entire class on way back in the day. So anyway, if you want to read the whole quote and get into the whole quote, you can watch the video. I'm not going to go through the whole explanation of everything there, but it's extremely telling, everything that's in this quote as to what they're doing, and it explains everything that I've already explained today, but in far more detail. Let's go back to the outline. Let's get on to P here. Another presumption is that you are 14th Amendment citizen, subject to the jurisdiction of the corporate Congress in DC, and not one of the people of your respective lowercase s state. So the Expatriation Act is document number 13, and let's go over that real quick. Now, the Expatriation Act was an act they had to put into place to basically counteract the 14th Amendment. What I mean by counteract is, they had to give you an out, and if they didn't, it would have been considered basically slavery. So you had a choice. You had a choice to stay an American citizen, which also is, you consider that one of the people of the several states in the Union, or you had a choice to be a citizen of the United States. Let's go through this so you clearly see that these are two entirely different things. So this is an act concerning the rights of American citizens in foreign states, in foreign capital S states. Notice that this was actually done in 1869, so this was just when it was republished, whatever. Rights of American citizens in 4 states, rights of expatriation declared, protection of naturalized citizens in 4 states, release of citizens imprisoned by foreign governments to be demanded. Facts to be communicated to Congress. Whereas the right of expatriation is a natural and inherent right of all people, not persons, people, indispensable to the enjoyment of the rights of life, liberty, and the pursuit of happiness. And whereas, in the recognition of this principle, this government has freely received immigrants from all nations, invested them with the rights of citizenship. Yeah. And whereas it is claimed that such American citizens, with their descendants, are subjects of foreign states owing allegiance to the governments thereof, and whereas it is necessary to the maintenance of public peace, meaning we'll kill you if you don't let us out of this, that this claim of foreign allegiance should be promptly and finally disavowed. Therefore, be it enacted by the Senate and House of Representatives of the United States of America and Congress assembled, that any declaration, instruction, opinion, order, or decision of any officers of this government which denies, restricts, impairs, or questions the right of expatriation is hereby declared inconsistent with the fundamental principles of this government. So, you have the absolute right to get out. Yep. And being further enacted, that all naturalized citizens of the United States, while in foreign states, shall be entitled, and receive from this government the same protection of persons, right? Persons, not people. So you got persons here, and you have people up top. Okay, two different things. Protection of persons and property is accorded to native-born citizens in like situations and circumstances. And be there further enacted, now this is where it gets interesting, that whenever it shall be made known to the President that any citizen of the United States has been unjustly deprived of his liberty, not freedom, by or under the authority of any foreign government, it shall be the duty of the President forthwith to demand of that government the reasons for such imprisonment, and if it appears to be wrongful and in violation of the rights of American citizenship, two different citizenships, the President shall forthwith demand the release of such citizen. So how do you get demanded to released? By American citizenship, not the citizenship of the United States. And if the release so demanded is unreasonably delayed or refused, it shall be the duty of the President to use such means, not amounting to acts of war, as he may think necessary and proper to obtain or effectuate such release, and all the facts and proceedings relative thereto as soon as practicable to be communicated to the President, to Congress. So, you have different citizenship here. You have American citizenship and citizen of the United States. Two entirely different things. Now, why do they have to state that? Because in the 14th Amendment, it talks all about the citizen of the United States, which we'll now open up and take a look at in comparison to this. Okay, and you'll see the difference. Number 14 is the 14th Amendment, so let's look that up. So the 14th Amendment, Section 1. All persons born or naturalized in the United States and subject to the jurisdiction thereof. So what if you're born and naturalized and not subject? Are you a citizen of the United States? And of the capital S state wherein they reside. If you say that you're a resident of Iowa, you just put yourself under the 14th Amendment. You are lawfully domiciled. That's what you are. You're not a resident. You're lawfully domiciled. That's a huge difference. That's the difference between by right or by privilege. Okay. So to continue, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. So what do citizens of the United States have? They have privileges, not rights. They have privileges. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. That's all civil rights, folks. Civil rights are rights granted by government. They're not unalienable. I'm going to skip this section 2, and basically the rest of it is just whatever. It's basically the first section that's the most important part. And then the fourth section they put in here from a standpoint, the validity of the public debt of the United States authorized by law, including debts incurred for payment of pensions and bounties for services in suppressing insurrection or rebellion, that's to pay their minions, shall not be questioned. But neither the United States nor any state shall assume or pay any debt or obligation incurred in aid of insurrection or rebellion against the United States. So we're going to set up a corporation, then we're going to say, well, no, if you rebel against our bullshit, we don't have to pay anything. Or any claim for the loss or emancipation of any slave, but all such debt, obligations, and claims shall be held illegal and void. Well, why? Because the slaves were never given freedom. They went from being private property to being public property. That's all that happened. That's all that happened. Oh, and I didn't really finish the story back. This brings me back to what I didn't finish before. I think this is back in section 1, when I was talking about marriage licenses. Marriage licenses came in from the standpoint after the Civil War because you had to get a license for a white to marry a black. You had to get a license for that because the corporate state was pimping out the ovaries of the black females, right? That's what they were saying. They were saying, well, if you want to do that, well, then you got to pay us. You have to have a license to do that. Messed up as that is, that's how it worked out. That's how it was. You don't see Thomas Jefferson and George Washington didn't have a marriage license. It came much later. And that was the reason. And then what they did was they sucked all the white people into the damn contract. And then in the aspect of the the birth certificates. Birth certificates were only originally supposed to be for single mothers that the fathers weren't around, so that the state could come in and be a daddy. That was where the birth certificate started. So you see how they're wrapping you up by contract? Okay, this is all contractual. Now you see the difference between what they did in giving you the out in the Expatriation Act to the 14th Amendment as to what they were trying to suck everybody under. So you have your out in the Expatriation Act from the standpoint of what it is. And then if you want to read the Foreign Sovereign Immunities Act, the link's here. And I'll drop it in meeting text too as well. That's the Foreign Sovereign Immunities Act, the link. And you can see, because we read some of that before, but that's the link to it. So you can get through and take a look at it. And remember that you are an organ of a foreign state. That's you. So with that concludes the first part of the class, which is all the presumptions that they use over us to diminish our status as one of the people and our sovereignty. So you have to get through all of that stuff to understand what they're really doing. And contracts are the next biggest part. Now, I'm going to go through contracts kind of quickly, sort of. I just want to kind of cover over it from the standpoint that people understand that there's all kinds of different contracts and when they're lawful and when they're not. And that the presumption of consent that you give to the corporate state when you enter into a contract with the agents thereof, that's how they're getting you, is by contract. As Thomas Jefferson put, the just powers of government are derived by the consent of the governed. There's no consent, there's no just government. It's pretty much the end of it. So let's open up, take a look at document number 15, which is the definition of the word contract from Bouvier's Law Dictionary. So to make a note here about what Bouvier's, the actual title of Bouvier's Law Dictionary is from a law dictionary adopted to the Constitution and laws of the United States of America and of the several states of the American Union, with references to the civil and other systems of foreign law. Roman civil law is foreign to us. Just in the very title of that dictionary, you can tell that, okay? So, contract. This term in its more extensive sense includes every description of agreement or obligation whereby one party becomes bound to another to pay a sum of money, or to do or omit to do a certain act. Or, a contract is an act which contains a perfect obligation. In its more confined sense, it is an agreement between two or more persons concerning something to be done, whereby both parties are bound to each other, or one is bound to the other. Blackstone's 2, page 442, defines it to be an agreement upon a sufficient consideration to do or not to do a particular thing. Again, sufficient consideration. A contract has also been defined to be a compact between two or more persons. Okay, so back to the consideration thing. That's why all of the status docs, they're all written up and done in, whenever we're talking about amounts of something, whether we're talking about posting the bond or so on and so forth, or even in the fee schedule, everything's done in amounts of gold and silver. Everything. None of it is done by saying millions of worthless Federal Reserve notes, okay? Everything's done by a dollar. A dollar is defined as a Spanish milled dollar of 1 ounce round of silver of 99.99% purity. That's the definition of a dollar. So we put that into the contract, that becomes the law, that's what they're bound to. Now the different types of contracts. Contracts are divided into express or implied. An express contract is one where the terms of the agreement are openly uttered and avowed at the time of making, so as to pay a stated price for certain goods. Express contracts are of three sorts: by parole or in writing, as distinguished from by specialty or under seal. The KW contract is a specialty contract. It's an express, it's specialty, and it's also implied, because when they act upon our estate, they've agreed by their actions to be bound to the contract. So I'm going to skip down to 6. There must be a good and valid consideration, motive, and inducement to make the promise upon which a party is charged. For this is of the very essence of a contract under seal, and must exist, although the contract be reduced to writing. Okay? So you got a valid consideration if you're going to have a contract under seal, which we do. So number 7, there must be a thing to be done, which is not forbidden, meaning it can't be unlawful, or a thing to be omitted, the performance of which is not enjoined by law, meaning, again, not that it's, you can't say have a license to kill or something like that, right? A fraudulent or immoral contract, or one contrary to public policy, is void, and it is also void if contrary to a statute. Now that's because statutes, acts, ordinances, codes, and public policy deal with bank and merchant affairs, but from a standpoint that this is also our will, we sort of get around that from a standpoint that this is dealing with everything that's ours already. But there's nothing in our contracts and nothing in the status docs that's unlawful anyway, so that it truly doesn't really apply when you have to worry about that anyway. As to contracts which are void for want of a compliance with the statutes of fraud, see frauds and statutes of blah, blah, blah. The second kind of express contracts are specialties, or those which are made under seal as deeds, bonds, and the like. They are not merely written, but delivered over by the party bound. Solemnity of the ceremonies to be observed, a deed or bond is presumed to be entered into. That's where we say that if they're going to administer any aspect of the estate, they have to put up a bond as a trustee. We're not being the ones putting up the bond. They have to put up the bond. If they fail to do so, we get to sue them for the amount of the bond anyway. Attached to it an importance and character to which do not belong to a simple contract. So this is the whole aspect of covenant thing, okay, coming into consideration here. In the case of a specialty, no consideration is necessary to give it validity, even in a court of equity. So get that. When you do something under seal, you can bypass the consideration. Now, we don't, but you can. So I'll skip down 20. Into reciprocal and unilateral. Into consensual or those that are formed by the mere consent of the parties. That's consensual. As such as sale, hiring, mandate, or those in which it is necessary and there should be something more than a mere consent, such as a loan of money, deposit, or pledge, from which their nature requires delivery of a thing, whence they are called real contracts. So ours is a real contract because we're requiring that they deliver our estate. Okay, so that makes it a real contract. It's also reciprocal, by the way, because if they produce and do what they need to do, we have in the contract now, there's a 10% carrot stick that says, hey, look, if you do what you're supposed to do and settle the entire gross estate and give me a full accounting and so on and so forth, well, then when it's all said and done, the total amount of the entire gross estate, 10% of that will go back to the trustee that helps you do that. Now it's 10% total, no more than 10% of the entire gross estate will be paid out. And it'll be paid out in equal shares of that 10% for however many trustees help you. So if only one trustee comes along and helps you and does all this, and they agree to be bound and everything else, and they produce everything, well, great, they get the whole 10%. But if not, then it gets divided into however many trustees help you out. So that's why it's reciprocal, because we give them something back for it. Because I'm not saying, look, okay, yeah, you guys administered this stuff for such a long period of time. Okay, great. There's a lot of mess to clean up here. There's a lot in accounting. Okay, fine. So we give them the 10% carrot stick so that we can state that the contract is reciprocal. We were going to give them, a cut. They just never took it. So, that's where you're being fair and equitable as well. You're having that balance of fairness to say, hey, look, we can do it. I'm ready to do it. Are you? It's either that or they can face everything else that they're going to have to face. So that's an aspect of contracts. Now, when the contracts are unlawful, well, we've already covered no consent, so on and so forth, under duress, that's the lack of consent again. Consideration, as we saw, unless, of course, it's under seal. So when we do the seal notice, status doc, what we're basically saying in the seal notice is that, look, we've established our house seal. This is what it is. So you put that on the public record as the seal of your house. And then what you also say in the seal notice, it says, look, every single contract or thing that has ever had the signature on it regarding that estate and trust that does not have the house seal on it cannot be considered to have been entered into knowingly and willingly with full knowledge and with consent. So what you're doing is you're putting a shadow of doubt over every single contract or trust or pledge or whatever with the corporate state that doesn't have your seal on it. That's what's protecting you. And the point is that if you ever get put under a contract or forced to sign something from them, say get out of jail bond or whatever, you can simply come back and say, look, I signed that under duress. Clearly, I already have a public record that says that if I sign anything without my seal, it's under duress. So it's invalid. That again would cancel the bond. And something else you could also put into the bonding company and say, look, it doesn't have my seal. And this thing I filed before that, and I've declared this to be so, and I haven't changed my mind about anything, so I signed this under duress. So there's null and void, right? So that's contracts. So we'll skip on down to section 3. I'll cover the grand jury stuff, and then, which will be a little bit, I'll go into the grand jury powers a bit. And then section 4 will be facts, evidence, and the law of the things of which you need to place into a court case every time. And then 5 will be how to prosecute an action at law, which will be the vast majority of time taken up for the rest of the day. And then I'll cover the 13th Amendment a little bit, and then there's some last links. So to move on to the ability and powers of the grand jury, let's open up number 16, which is a section from my grand jury handbook, which I'm finishing up, but not quite done with yet. So this is part 2, History of the Grand Jury, chapter 14. Our American system of common law and common law courts of record and grand juries are a direct result of the culmination of the history of law and the struggle of the people of England and the struggle of the people of the American colonies and the oppression exerted by Rome over the last few thousand years in opposition to the common law, both by the Roman civil law and the ecclesiastical law. In our American organization of jurisprudence, the people always have full control of all aspects of law in the constitutional republics. If a felony or infamous crime has been committed by someone, which under the common law must have a party that has had a damage, harm, loss, or injury done to them by another, it falls to the grand jury to investigate the crime. This usually is accomplished by the grand jury investigating the matter and creating what is called an indictment against the accused. So here's the definition of an indictment. Again, this is from Bouvier Law Dictionary. Indictment. Criminal law. Practice. A written accusation of one or more persons of a crime or misdemeanor presented to and preferred upon oath or affirmation by a grand jury, legally convoked. So you bring indictments to the grand jury. The grand jury can also create their own indictment if they want to. So when you bring an indictment to a grand jury, what they do is they sign it as a true bill or a no bill. They say, yes, this is a true bill of indictment, or this, nope, this is a no bill. So we're not going to go along with that. The word indictment is said to have been derived by the old French word inditter, which signified to indicate, to show, to point out. Its object is to indicate the offense charged against the accused. Number 3, to render an indictment valid, there are certain essential and formal requisites. The essential requisites are, first, that the indictment be presented to some court having jurisdiction. So the way to properly do this is that the grand jury would create an indictment, and then they'd bring the indictment to a court of record. 2, that it appear to have been found by the grand jury of the proper country or district. That's the aspect of venue, that they have to do it in the proper venue, because you don't want a grand jury stepping on the toes of a grand jury of another county. So keep your counties by counties. Now, if you can do a state grand jury, that's fine when it deals with matters of the entire state. But when it's dealing with matters of your county, you don't want to trespass upon another grand jury's venue. 3, that the indictment be found a true bill and signed by the foreman of the grand jury. 4th, that it be framed with sufficient certainty. For the purpose, the charge must contain a certain description of the crime or misdemeanor of which the defendant is accused and the statement of facts by which it is constituted, so as to identify the accusation. And 5th, the indictment must be in the English language, but if any document in a foreign language as a libel be necessary introduced, it should be set out in the original tongue and then translated. 2nd, formal requisites are, first, the venue. That's what I said before. So what county are you in here? What are we doing? Which at common law should always be laid in the county where the offense has been committed. Although the charge of this nature historically is in a nature transitory as battery. The venue is stated in the margins. They used to be up and down the side of the papers. So in the sides here, it used to be up and down as to city and county of blah, 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 to wit. And then the presentment, which must be in the present tense and is usually expressed by the following formula. Quote, the grand inquest of the Commonwealth of wherever, inquiring for the city and county aforesaid upon their oaths and affirmations present. So that's a good basis of what you'd want to write out when you did that as a grand jury. There are other forms of other aspects that I have in the grand jury manual too, which will help people out when they originally come together and form a proper grand jury of the peerage. It must include the name and addition of the defendant, but in a case of error, it has been made in respect. It is cured by the plea of the defendant. So basically a misnomer. So if you misname the person, you can fix it later. Names of third persons, when they must be necessarily mentioned in the indictment, should be stated with certainty to a common intent, so as to sufficiently inform the defendant as to who are his accusers, meaning, who's coming, the people of what, wherever, right? And the rest of this is fairly lengthy, but all of this is spelling out what needs to be in the indictment, okay? So I won't go through the rest of that. You can read it at your leisure, or when you decide to finally convene a 25-member grand jury, you can follow through with it, okay? So to continue with the grand jury manual, if the grand jury feels that it is not important to prosecute the matter, the grand jury passes a no bill, and that's as far as it goes. In the colonial days, it was widely known that when many of the agents of England would bring a matter to a grand jury that dealt with some incident in which the colonists had strong feelings about, the grand jury would pass a no bill on the matter, just despite the king and his men. Vice Admiral to the king once wrote to the king and complained that, quote, by night the colonists violate the king's laws, and by the day they set the same men free by refusing to indict by the grand jury. Yeah, well, too bad for the king. And that's still the point. The grand jury is referred to, as it should be, the fourth leg of government. So it's above everything. Pretty much the only thing a grand jury can't do is impeach the president, because technically we vested that power to Congress. To continue, the grand jury can be said to have celebrated its 800th birthday in 2015, because the establishment of the grand jury is defined in Article 61, the longest of the 63 articles of the Magna Carta, executed on 15th June 1215 by King John and the barons of England. So we can pause here for a minute, bring back up the Magna Carta, and then go take a look at that article, Article 61, which you can see is by far the longest article. Okay. Now, the parts in red here are the main parts regarding the grand jury. So, inasmuch as, but I'll start from the beginning, inasmuch as for the sake of God and for the bettering of our realm, and for the more ready healing of the discord which has arisen between us and our barons, we have made the aforesaid concessions. Wishing them to enjoy forever entire and firm stability, we make and grant to them the following security. That the barons, namely, may elect at their pleasure 25 barons from the realm, who ought, with all their strength, to observe, maintain, and cause to be observed the peace and privileges which we have granted them and confirmed in this our present charter. In such wise, namely, that if we, our justice, or our bailiffs, or any one of our servants shall have transgressed against any one in any respect, or shall have broken some one of the articles of peace or security, and our transgression shall have been shown to 4 barons of the aforesaid 25. Now that's basically what turns out to be the investigators of the grand jury. 4 people can go around and say, look, we're investigators of the grand jury. We're 4 of the 25. We have questions for you. And you could walk into any government building and do that. And they would basically have to answer every single thing that you had before you. So as long as you have 4 walking around with you, and you say that, you say, we're investigators of the grand jury, we're members of the grand jury investigating here, they pretty much have to back down and give you whatever you want, okay, because of that. So it's right in the Magna Carta here. Those 4 barons shall come to us, or if we are abroad, to our justices, showing to us our error. So basically, once the 4 investigators come and say, hey, we've got a problem, to nowadays the corporate state, they pretty much have to do something about it. And they shall ask us to cause that error to be amended without delay. And if we do not amend that error, or we being abroad, if our justices do not amend it within a term of 40 days from the time when it was shown to us, or we being abroad, to our justices, the aforesaid 4 barons shall refer the matter to the remainder of the 25 barons. And those 25, with the whole land in common, meaning everybody, shall distrain and oppress us in every way in their power, namely by taking our castles, lands, and possessions, and in any other way that they can, until amends have been made according to their judgment, saving the persons of ourselves, our queen, and our children. So you can't go after him or the wife or the kids. But you can take all his stuff, okay? You can take all of the government stuff. And when amends have been made, they shall be in accord with us as they had been previously. So this gets into the power now. And whoever of the land wishes to do so shall swear that in carrying out all the aforesaid measures, he will obey the mandates of the aforesaid 25, and that with them he will oppress us to the extent of his power. And to anyone who wishes to do so, we publicly and freely give permission to swear, and we will never prevent anyone from swearing. Moreover, all those in the land who shall be unwilling, unless themselves and of their own accord, to swear to the 25 barons as to distraining and oppressing us with them, such ones we shall make to swear by our mandate, as has been said. So that's basically saying, anybody that the grand jury wants to swear in, come along with it. So I say the grand jury swears in the whole entire militia. Let's go get something done. That's all the power that you ever need right there. Put those two things together. We have all the power. We always have here. We're just not wielding it. We're not wielding our power as to what we can and should do. Close that down. Let's go back to Grand Jury Manual. The Fifth Amendment of the Constitution of the United States reads, "No person shall be held to answer for a capital otherwise infamous crime unless on the presentment or indictment of a grand jury, except in cases arising in the land or naval forces," so military, right? Military law. "Or in the militia when in actual service in time of war or public danger." Again, military law. So, you have to have a grand jury indictment against you, unless you're in the military. And to not make that a point in court is a grievous error. So, anyway, to continue. In the early decades of the United States, grand juries played a major role in public matters of all kinds and should still be used in the same way today. Any people could bring a matter before a grand jury directly, from a public work that needed repair, to the delinquent conduct of a public official, to a complaint of a crime, and all other manner of issues regarding the protection of the realm of which the grand jury had jurisdiction over. The grand juries can also conduct their own investigations into what they themselves have gathered in regards to information that shows evidence of damage, harm, loss, or injury. As I said before, the 4 investigators can go out and pretty much investigate whatever they feel like. In the early era of America and before England, the most criminal prosecutions were conducted by private parties. Either a law enforcement officer or a lawyer hired by a crime victim or his family, or even a layman. A layman would bring a matter to the grand jury in his own volition. If the grand jury found there was sufficient evidence for the trial, that the act was a crime under the law, and that the court had jurisdiction, it would return a true bill on the indictment to the complainant. The grand jury would then appoint the complaining party to exercise the authority of an attorney general. That is, one having a general power of attorney to represent the state in the case. The indictment was in the name of the people of the state of whatever, Iowa, and concluded, against the peace and dignity of the same. That's how you write out a proper indictment. So it's in the name of the people. It's not the state of Iowa versus whoever. It's in the name of the people. That's who has to bring the indictment. Okay. So the grand jury served to screen out incompetent or malicious prosecutions in both American jurisprudence and in English. The advent of official public prosecutors in the later decades of the 19th century largely displaced private prosecutions, but that doesn't mean we can't still do it. Okay, you don't need these district attorneys. You can do it yourself. But has in no way removed the ability of private prosecutors from exercising their rights to prosecute in the name of the people of a state for a crime committed against one or all of the people. The Massachusetts Bay Colony impaneled the first grand jury in 1635 to consider cases of murder, robbery, and wife beating. As early as 1700, the value of the grand jury was recognized in opposing the royalists. These colonial grand juries expressed their independence by refusing to indict leaders of the Stamp Act, and a Boston grand jury refused to bring libel charges with other colonies to oppose British taxes, and was supported by a Pennsylvania grand jury in 1770. While all states in America currently have provisions for grand juries, today approximately half of the states employ them, and 22 require the use to varying extents. The Constitution of Pennsylvania required between 1874 and 1968 that a grand jury indict all felonies. Currently, only 2 countries in the world use grand juries. It's the United States and Liberia. It is noteworthy to mention that no public official has immunity to a grand jury subpoena. There have been some very notable cases in where the President of the United States was required to testify before a grand jury. The grand jury's theoretical function against abuse of excessive power was seen during the Watergate crisis in America, in the United States versus Nixon, and the U.S. Supreme Court ruled 8-0. 23rd July, William Justice Rehnquist, who had been appointed by Nixon, recused himself from the case. That executive privilege applied only to the co-equal branches, the legislative and judicial, not to grand jury subpoenas, thus implying a grand jury constituted protections equal to a 4th branch of government, period. Thank you. Because guess what? That's what it is. Nothing is above us. Nothing when we properly form a grand jury. This is the main point. This was the main reason why we chose to set up and establish Discord. This reason, for everyone to understand their power under a grand jury. You have that full power, you take it back, you can do anything you want to. You can subpoena a president. Okay? You can subpoena any document from any corporation, which I'll get into in a minute here with Hale versus Hinkle. But to continue. The second Watergate grand jury indicted several lawyers in the White House, including former Attorney General John Mitchell, and named President Nixon as a, quote, secret, unindicted co-conspirator. Despite evading impeachment, Nixon was still required to testify before a grand jury. So notice that. He quit before he got impeached, but you get summoned by a grand jury as far as a subpoena is concerned. You either show up or you can be held in contempt of the grand jury and they can just throw you in jail. For as long as they want to. Until you start telling your story. Or until you start giving up the documents, which I'll get into in Hale versus Hinkle. Similarly, in 1998, President Clinton became the first sitting president required to testify before a grand jury as subject of an investigation by the Office of Independent Counsel. The testimony came after a 4-year investigation into Clinton and his wife Hillary's alleged involvement in several scandals, including Whitewater and the Rose Law Firm. Well, they've got quite a bit more stacked up against them now. Revelations from the investigation sparked a battle in Congress over whether or not to impeach Clinton. This again shows the ultimate power of the grand jury and shows that when the people use this tool of the common law to be the ultimate security of their realm, no one is immune. The grand jury is also known as the People's Panel. Every one of the people should know the history and purpose of the grand jury in order to properly protect his fellow man from prosecutorial abuse, and to investigate public trustees who would exceed their jurisdiction or abuse their power whilst holding office as a public trustee. When the people are unaware of their power, they cannot exercise that power to uphold justice. When the people are fully aware of their power, they can exercise said sovereign power with diligence and purpose, without fear, and in accordance with natural and common law principles for the betterment of their society. So, Chapter 15. Magna Carta and before. The end of law is not to abolish or restrain, but to preserve and enlarge freedom. For in all the states of created beings capable of law, where there is no law, there is no freedom. John Locke. It has been said by some that the origin of trial by jury has been lost in history. However, it is known that before 1066 in England, and for at least 200 years before that date, there was a kind of grand jury in the various areas of England, called the 100 Court. This was the court of the county, which was, at the time, called 100. These 100 courts, for all intents and purposes, were how the people dealt with matters on a local level, and were the precursor to the security of the realm spoken of in the Magna Carta, wherein we get the first semblance of what our current grand jury now looks like. It is said that the Court of 100 was a court of 100 families, with what was then later called a county. So these things became, the aspect of how many people were in an area, the 100 families became a county. However, as the population grew, there became to be several hundred in a county that made up a larger group known as shires. As a side note, it would be a very good organizational tool to organize people in the county into groups of 100 families again, and have a grand jury for each 100, thereby reviving this ancient organizational structure, which there's nothing saying we can't do that. For as it is known in human sociology, people only consider about 250 people to be in their basically community. Everyone else is just basically other. This is the same no matter where on the planet you go. Okay? And from that standpoint, I can't think, but the more ancient peoples were well aware of that, and they knew that everybody that was in there, they knew them. There was the community. Yep, I know all these people. Yep. And you were other. I don't know you. So what are you doing here? Where'd you come from? Would you like to join? Okay, who are you? Right? That's how you keep thieves and filthy Luciferian scumbags out of your society. You don't let them in. The Vikings had a different way of convening a large jury to settle matters before them. For the 300 years starting out around 793 AD that the Vikings plundered and raided the coastal cities across Europe and England, these warring people were strongly bound to the law of their land. As early as the 6th century, the Vikings in Norway had established a government based around what were known as the Things. This was the name given to what we would call a popular assembly. These regular meetings of the local area were convened to affirm laws, settle conflicts, and award judgments. Even the kings were elected from or at the quote-unquote Things. And they too, as the rest of the people, were bound to obey the law. It is even said if the king broke the law, it was the duty of the people to capture and kill him. Yes, that's what that said. Or banish him for life. Around the 10th century in Iceland, there were held annual meetings in which was open air and called to a place called Thingvellir, which means assembly plain. This was held for 2 weeks each summer, and at it, a law speaker recited the existing laws for all to hear. Now notice, that's all spoken. That's all law spoken by oration. That's real law when you speak the law. When you write down the law, that's technically a dead form. Okay? So then just to make a note here, that Roman civil law still, the highest form of law is spoken. It's not written, it's spoken. So when you go into court and you have various different papers and you're doing your thing and whatever, and you file your action, if the judge ever says to you, or magistrate if you're in a court of record, ever says to you, is there anything you'd like to add? Shut up. Say, no, Your Honor, I stand on my paperwork. Then that forces him to look at your paperwork and nothing else. If you start blabbering, everything that you just wrote, all of the time that I or anybody else put into your paperwork is null and void, gone. It's out the window. Pointless. Because you just superseded it by your oral law. Now, if you think you're good enough to walk into a court and do it all orally, fine. By all means, do so. But I wouldn't suggest that. These judges are highly trained in rhetoric. They will change tone. They will change attitude. They'll change aggression. They'll be good cop, bad cop within seconds. They will ask you questions that you have no idea the proper answer to, and then they'll ask you, did you mean something by such and such of a word that you said that's not what you meant? And they use 2 or 3 different words of definitions that you don't know. So, better off not to do that. Just stand on your paperwork. So anyway, to continue. So this court for grievances was held, and the judges, witnesses, and litigants swore solemn oaths, and witnesses could only testify to what they themselves had heard and seen. Right? So, obviously, no hearsay here. The penalty for perjury was immediate execution. Yep, you heard that right. Got caught lying, you got your head taken off. Imagine how different attorneys would act if they tried to start testifying before a court and you said, objection, Your Honor, the man's testifying. And by the way, he's lying. Kill him. That'd be pretty quick justice. I would have no problem with that at all. Many men heard the trials and judges and the outcomes. So in these assemblies, the Vikings had their own form of a grand jury, which was deadly serious. Okay. The origin of the grand jury in the current form of American jurisprudence dates back to 1215, and this goes back to Magna Carta, which I just read, so I won't recover that. And I'll leave the rest of the English procedure as far as, because this is kind of covered in the grand jury or the Magna Carta as well. So I'll leave this. You can read it on your own ledger, the aspect of how people were brought forward and the sheriff and whatnot. And also then you can read American procedure as well. The grand juries from England were brought to the American colonies and how we did what we did. And that's another few pages of information there that you can read, again, at your own leisure. And if you want to learn more information about grand juries, I suggest going to 1215.org, and Bill Thornton has a lot more information about grand juries and process on there. So for that, we'll leave the importance and the aspect of the grand juries to the rest of the handbook anyway. The definition, we can open up the definition now. 17, this is again from Bouvier's, and I'll cover up the definition here of grand jury. A grand jury practice, a body of men consisting not less than 12, no more than 24, respectively, returned by the sheriff of every county to every session of the peace, or intermeter and general jail delivery, to whom indictments are preferred. That's Black's Law's Commentaries. That's why it's written so funny. It is important to note here that in the Magna Carta, it requires 25 members of the peerage to come together. Ever wonder why the corporate state has never lets more than 24 people in one place? That's because if you had a proper grand jury of 25, you could be able to do whatever you needed to do. Okay. Now, I don't really think that they would dare to, if you formed a grand jury of less than 25, that they would dare to say, well, you don't have 25. Yeah. But at the same time, it's just better to just do it properly and just get it done right. There is just reason to believe that this institution originated among the Saxons by the Constitution of Clarendon, enacted in 10 AD, has provided that if such men were suspected, whom none wished or dared to accuse, the sheriff bring thereto required by the bishop should swear 12 men of the neighborhood or village to declare the truth respecting such supposed crime, the jurors being summoned as witnesses or accusers rather than judges. if this institution did not exist before, it seems to be pretty certain that this statute established grand juries or recognized them if they existed before. So again, the aspect of the understanding that the 100 court was kind of the precursor of the grand jury, but this specifically saying that the jurors being summoned as witnesses or accusers rather than judges. That's the point. That the grand jury is an aspect of an accusatory body. But as you see in the Magna Carta, it can also finish its business too. So this is kind of where you're seeing the precursor, and then they really come in 1215 to say, okay, nope, we're going to totally take all the power to be able to do it. But that's, of course, you have to have 25 members of the peerage. This isn't just, infants throwing sand in a sandbox. You gotta be out. Number 3, a view of the important duties of the grand juries will be taken by considering the organization of the grand jury, the extent of its jurisdiction, the mode of doing business, the evidence to be received, the duty to make presentments, the secrecy to be observed by the grand jury. A lot of this I cover in the grand jury manual, but it's all covered here in the definition. As far as if you want to know how to do these things, it's pretty much in the definition of grand jury in Bouvier's. The rest of it, of process and procedure, you can find in treatises, because there are treatises on grand juries. And remember, whenever you're looking up something and you want to learn about law, the first thing you want to do is go find the treatise on a subject. That's the text that you want to go find to learn about a subject. You go find the treatise on it. So you can find treatises on grand juries, and it'll explain all of this more in detail from a standpoint of, foreman acting as president, to look in practice to find a true bill, make sure of the evidence being received, ascertain the facts which the jury have not themselves witnessed, but must depend on the statement of those who know them and who will testify to them. So they swear people in before them. All right. Say, what happened? Okay, this, that, next thing, da-da-da. And then based on that, they then create a true bill, and then they give it to a court of record to be tried. But the point of the grand jury is to gather as much information as you possibly can. So, because the thing about a court of record, and I'll get into this later too, but the point of a court of record, one of the things about common law is that there's no discovery. Discovery is an equity procedure. Discovery is not something that's known at law. There's only one thing at law that you can do that has with it the kind of the same aspects of discovery as are in equity, and that's an action of account. In an action of account, you're proving the fiduciary relationship between two parties. And once you prove that fiduciary relationship, that one owes an accounting or holds something of someone else's, or say the accounting of a trust or a trust fund or something. When it's in question, you sue out an action of account, and you say, give me a full accounting. Okay, in that action, which is common law, there is a form of discovery, if you will, and that's that you can demand, after you prove the fiduciary relationship exists between the two parties, to produce the account. And an action of account may very well be an action that we end up taking against Fidelity, DTCC, State Treasurer, Treasury of the United States even, to say, look, where's my stuff? So anyway. So to continue down here, I was down at 9. Should any member of the jury be acquainted with the fact on which the grand jury are to act? He must, before he testifies, be sworn or affirmed as any other witness, for the law requires this sanction in all causes. So if you actually have some member of the grand jury that actually knows something about it, they also have to be sworn in, just as any other witness would be. As the jury are not competent to try the accused, but merely to investigate the case so far as to ascertain whether he ought to be put on his trial, they cannot hear evidence in his favor. Well, again, there's no set rules for grand juries, so they can go both ways if they want to. It's really up to them. Theirs are a mere preliminary inquiry. That's true. It is when he comes to be tried in a court that he may defend himself by examining witnesses in his favor and showing the facts of the case. Yes, that's true as well. Because technically, you being the grand jury, you are kind of acting as a preliminary plaintiff of the realm and saying, look, we think this guy did something bad. But at the same time, if the district attorney or somebody comes in and says, hey, I have this indictment against so-and-so, and it's Joe Blow, whoever, who was walking down the street with his AK-47 strapped to his back and a sidearm. I said, I want you to indict him against, such and such statute. The grand jury can look at the district attorney and say, get the hell out of here. Do you have any proof that he's not one of the people? Right? That's the grand jury just slapping the face of the stupid prosecuting attorney saying, get out of here. We're not trying anything like that. He has the right under Second Amendment. Get out of here. Be gone. So anyway, the protection of the people from the standpoint of the grand jury is part of the aspect of what I was talking about before, when the colonists would basically say, nope, we're not going to indict. Have a nice day. So, number 11, of presentments, the jury are required to make true presentments of all such matters which may be given to them in charge, or which have otherwise come to their knowledge. That's if they decide to go out and investigate on their own, too. A presentment, properly speaking, is the notice taken by the grand jury of any offense of their knowledge, as of a nuisance, a libel, or the like. In these cases, the authors of the offense should be named so that they may be indicted. Now, to get into an aspect of the four investigators, right? Well, it doesn't just have to be four. It can be the whole bloody grand jury if you want it to be. There was a story, as I recall, that there was a grand jury in... Oh, and I'm going to preface this story with something. If you really wanted the power of a grand jury, what you want to go do is just look for one term. Look for the term runaway grand jury. Because what did they do? They ran away from the stupid power of the state and said, no, we're going to do this on our own. So if you ever want to see real powers of grand jury, look up every single report and procedure of every single quote-unquote runaway grand jury, and you'll see the real power of a grand jury when they really decide to do something. Which they did, as I recall, in a story that happened after the Second World War, I believe it was in the 50s or 60s, in Minneapolis, St. Paul. There was some pretty big corruption going on. Their mayor and chief of police were involved, and this intelligent foreman of a grand jury basically took it upon himself to start investigating. The district attorney tried to get in his way, and he said, you get in my way, I'll prosecute you too. Get out of here. They hired their own investigators, paid it out of their own money, and investigated the mayor and the chief of police. After they brought indictment, the foreman himself prosecuted the case in a court of record and got rid of both of them. So, when you want to talk about absolute power from start to finish, that's what you can do. Because the grand jury can appoint a special prosecutor, and if it wants to be the foreman, fine, go ahead. Or anybody else that can do it. Go ahead. Off you go, right? Took them both out. So, that's your real power there from start to finish. You want to. So it's all part of one part of the puzzle, kind of, from start to finish. So you keep it in there. So there's a little aspect about presentments. And then the secrecy, the oath of which they have taken, obliges them to keep secret the Commonwealth Council, their fellows and their own. So you not only are they that you have the right to keep things secret in a grand jury, you basically take an oath to keep it secret. Because you don't want to give out the information of someone that may have an indictment coming against them to be able to run or get away or whatnot, right? Although contrary to the general spirit of our institutions, which do not shun daylight, the secrecy is required by law for wise purposes. It extends to the votes given in any case, to the evidence delivered by witness, and to the communications of the jurors to each other. The disclosure of these facts, unless under the sanction of law, would render the imprudent juror who would make them public, meaning go and tell somebody about them, liable to punishment. So that's, you don't want people running off and telling someone that, hey, there's an indictment coming, you might want to get out of town. So with that, grand jury definition, I'll get back. We'll get into some grand jury case law, and then that'll finish off the grand jury when we come back. As long as there aren't any questions.
I do have a question.
Okay. Yep.
Yeah, I was going to ask you in the court case I got coming up. Since they haven't indicted me from the grand jury, can they really go forward?
It's not considered an infamous crime. That's why you have difference between felonies and misdemeanors. But the standpoint of a misdemeanor, it's a commercial crime. It's a commerce crime. It's a traffic ticket. So if it's a traffic ticket, they have to prove commerce. And if they don't prove that you're engaged in commerce, then there's no jurisdiction. So how you do that is you force them to prove jurisdiction to a superior court of record. So you become the plaintiff. You file, and I'll get into all this, and this will be the last part of the day, by the way. Pretty much all the rest of the day will be spent how to file a court of record and what on and so forth. So I'll kind of be answering this question later. But in the preliminary, you have to make yourself a plaintiff and make them prove they have jurisdiction over you. And you do that by stating what you are and not what you're not, and you force that by saying, I was traveling, and you have to prove otherwise. So basically they would have to prove a manifest or or a contract or something along the line. The one thing that I want you to do to focus on is not so much, you need to focus on finishing your court of record suit. Have you worked out the template yet off of Phil's template to add all your facts and what happened in the suit?
I'm in the process and I have some questions about it, but that executive letter is very short. It's was my first step so that I could to get a number so that I could file the darn thing.
Oh, the only thing you have to do as far as getting a number is concerned for a court of record, an at-law case number, is just walk into the clerk of the court and say, I demand that this be filed at law. I demand an at-law. I demand that this be filed.
Yeah, because it's closed down, so I had to send an executive letter through Drew.
Oh, you can always call them too, though. You can always call them and demand it over the phone too, and say, I'm recording this call. I'm filing such and such suit, and for the record, I'm recording this call. File on demand, assign an at-law case number to it, and send it back to me. You file stamp it and send it back to me. So you can record a call too, because anytime that you get a clerk in a position where they're not doing what they're lawfully supposed to be doing, record the call, because then that's proof.
I sent the executive letter through Drew, which is a notary presentment. So I figured that's, under my seal. And I figured, I demanded. I didn't ask, okay. I demanded.
Well, if it's under your seal and you demanded it, then yeah, they got to do it. And then the proof that you sent it to him, then Drew is just proving, as far as the presentment, that he sent what he sent. And then he keeps a copy of it and swears under penalty of perjury, under his standpoint, that, yep, that's what you sent to him. And that's what they got. So yeah, you can bring that up later if they try to secret from having an at-law case number. So you can come over the top of them after that. Does anybody else have any other questions on that section for grand jury?
How many people do we need to go and get Eric Holder?
Well, the standpoint of that, I said I doubt that they would balk. If you didn't have 25, you said, hey, we're a grand jury and we get 23 or something. But you want to do it from a standpoint to have 25 out, 25 people. I mean, 25 de jure citizens of the state, not citizens of the United States, bring an indictment for a grand jury. And then, then you can subpoena anyone. If there was something that he did from a standpoint of in your realm that you find to be wrong or cause damage, harm, loss, or injury, then you can bring the indictment and he has to show up because the wrong was done there. So you can subpoena him.
So it has to be per state rather than people that are American citizens.
You can have a federal grand jury as well. Yes, you can. But I would, before you go off and do a federal grand jury as far as 25 members, I would have 25 people out that have done their status docs, and I would serve the Attorney General of the United States Federal Corporation and say, look, we're doing a federal grand jury here. We're going to do it in secret. There's 25 of us. And by the way, here's all of our status docs. And there really wouldn't be anything they could say after that. And then, you could do it from a federal standpoint of saying things like treason. I mean, technically, if you do a federal grand jury, there's really only 4 crimes, technically, under the federal Constitution that you have the right to prosecute. And does anybody know what they are off the top of their head? Okay, I'll take that as a no. The only 4 crimes that the feds can then have the right to prosecute at all, it's under Article 1, Section 8, is treason, counterfeiting money, piracy, and the law of nations. That's it. Everything else is on the state side. Everything. So it's now technically under piracy. You could stretch it from a standpoint of bringing a federal piracy doc or a piracy suit against land pirates, against these corporate cops that are out here running around with letters of marque that are seizing you. I would go so far as to call that inland piracy. That's perfectly fine. So you could do a federal indictment, that aspect, and just as long as you put it under piracy. But then everything else other than those 4 things should be done on the state side. And always have been done on the state side, mind you, until they started messing around and making all crimes commercial and then bringing everything in after they did after 33. So is there any other questions? No? Okay, with that, then let's take a break and then come back.